We're then going to finish the panel with our last speaker. Last but by far from the least is Danielle McMullan, a colleague of mine who is the senior researcher on labour rights, but has been working especially over the last year in particular on modern slavery. She's the person who has done the work that we've done on the analysis of the modern slavery compliance statement so far, as well as led on all the research around the apparel and Syrian refugees in the apparel sector in Turkey over this last period. So Danielle will speak to us about the Modern Slavery Act Registry and about the analysis that we have around the company statements as they've come out so far. Thank you.
Thanks. So with the Modern Slavery Act, what we're seeing is a clear legislative trend towards mandatory transparency and due diligence. Of course, it's preceded by the California Act, but by the end of the year, all the EU states will have to transpose their EU Non-Financial Reporting Directive, and that will impact roughly 6,000 companies across the EU. In France, as Phil mentioned at the beginning, there's draft legislation that will require large companies to produce a due diligence action plan, and that's currently going to the Senate for approval. In Switzerland, the government has got to consider an amendment to the constitution that will force companies to carry out mandatory due diligence, and that's ultimately going to be put to the Swiss public in a referendum. And in the US, as well as the federal level bill, which might not stand much chance of becoming law, there is also the action that the Obama administration took earlier in the year that gives the power from the US Border Agency to prevent the importation of goods made with forced labour. So what we're seeing is the space for companies to operate with using modern slavery is shrinking. And we've talked a lot this evening about the potential for litigation concerning modern slavery, and that will obviously be on the minds of a lot of companies in-house counsel as they're considering drafting their modern slavery statements. And I think the message here is that carrying out due diligence, so being aware of the risks in your supply chain and taking steps to combat that, and then being honest about the risks and the steps that you're taking in your modern slavery statement, will actually protect companies from taking actions against them. And I think, especially as we move along the trajectory, not just on mandatory reporting, but what will eventually become mandatory due diligence, that will become even more the case. Now, the support of leading companies and investors for the supply chain element of the Modern Slavery Act was absolutely key in convincing the government to include it. And I think those businesses would be rightly commended for their role in that. And this support is obviously very welcome, but it shouldn't mask the fact that most companies actually aren't in a position and have a long way to go to demonstrate that they are combating modern slavery and conducting due diligence to eliminate the curse from their supply chains. Together with CORE earlier in the year, we conducted an analysis of the first 75 statements that companies have produced under the Modern Slavery Act, and what this uncovered was that there's widespread misunderstanding from companies about what's required of them. Even on a basic level, as we know, the requirements in the legislation, there is nothing dictates about the content of the statement, but there are requirements, as I think probably most people here know. Firstly, that the company has to get the statement approved by the board of directors and it has to be signed by a director. And secondly, that the statement has to be available via link from the company's homepage. And what we found was that only 22 of the statements we looked at complied with both of those basic requirements. Only 9 of those statements complied with both of those requirements and actually addressed the 6 criteria laid down in the legislation, which the government said a statement may include. Very few went into the kind of details that we would be hoping for. They were fairly generic statements, particularly in regards of identified areas of risk. And I think this is concerning because it suggests that companies are not actually taking that initial first step, which is actually to understand the risks in their supply chain, to undertake that mapping exercise and that risk assessment. And of course, these are the first reports, and it's perhaps not reasonable to expect all those due diligence systems to be in place at this stage, and we hope they will be in place as the years go past and the statements are repeated. But what it does suggest is that many companies are looking at this as a compliance exercise. They're a box to tick, they put up their statement, they've complied with the Modern Slavery Act. And what I think they're failing is that the aim of the legislation is not to get companies to write modern day slavery statements, actually to get them to take action on modern day slavery. And only through doing that will they be able to write a good statement. Over the last year, and perhaps a bit longer than that, we've seen many consultants, lawyers and advisors enter the field, providing services to companies in relation to modern slavery. And some of these will undoubtedly be good partners for companies. They'll be able to help them, companies that haven't addressed this before, be able to help them to identify areas of risk. They'll also be able to help them put due diligence systems in place. But there are also those consultants that won't be providing that kind of service, and they won't be doing companies any favours in doing that, because as there is more scrutiny from civil society, that will be exposed. Ergon did a very interesting analysis of I think there's so far been about 240 statements published a couple of weeks ago. And one interesting finding in their research is that they found very similar wording in some of the longer statements, and they even had the same KPIs. And I think that should really act as a warning to all of us that we really need to keep up the pressure and to ensure that companies break with this compliance approach. As the government repeatedly made clear, they don't intend to take enforcement action on this. So it will be for us, civil society, advocates within companies, to ensure that we fight back against that approach. I think the Act is also an opportunity for companies to move away from the failed systems of the past. Companies that think that they're going to be able to demonstrate they're taking appropriate steps just by carrying out a few announced audits in their supply chain are deluding themselves. And we need to make sure that companies looking at this for the first time, as well as companies that have struggled with these issues and have been under the spotlight for these issues for years, know that the only credible approach is a collaborative one. This is something that we saw come through strongly in our work earlier in the year, looking at exploitation of Syrian refugees in Turkish garment factories. The majority of the companies were carrying on with their audit and monitoring systems. A lot of these audits were announced. They were perhaps not penetrating below the first tier, and they hadn't grasped, or perhaps didn't want to grasp, the real seriousness of the situation and the risks that were in their supply chain, the exploitation. It was companies that were working much more collaboratively with local NGOs that were providing support services to refugees like Next and Primark, that had a much better grasp of actually what the risks were in their supply chain. And I really think that's an important thing for companies to take on board, the importance on collaboration, because it's not within any company's gift to solve this issue on their own. I think the Act provides an opportunity not just on modern slavery, but on business and human rights more broadly. We've seen it already force conversations within industries that have never looked at business and human rights issues before. So it does provide a real space and opportunity for us to embed human rights due diligence deep within companies. And the government should be rightly praised for being an early mover in mandatory transparency reporting. But what I think we need to look for with the next generation of modern slavery legislation is, wherever that may be, Switzerland, France, is to ensure that mandatory due diligence is going to be enshrined in law. Because while we have people really still living pitiful existences, as we've heard in Shanta's case particularly, being treated like commodities, like a piece of wood, it's clear that there's still so much more for us to do. But in the words of Martin Luther King, the arc of the moral universe is long, but it bends towards justice.